Sethi, and I welcome you all for this very informative webinar on intellectual property rights, brought to you by PRACOLEARN, an initiative of Saxena and Kumar Law Chambers. Saxena and Kumar Law Chambers is a leading law firm in Noida, established in the form of a limited liability partnership and working in areas of legal consultancy, practical implications of law, and paralegal services. PRACOLEARN imparts and focuses on practical knowledge of law. It does act as a bridge between theoretical knowledge of law and its practical aspects. PRACOLEARN has a motto to holistically cover all the practical aspects that are necessary for the professional world. It is committed to train students to become accomplished professionals. I will now welcome you all and introduce to you all our respectful panelists, Mr. Anupam Sinha sir and Mr. Abhinav Saxena sir. Mr. Anupam Sinha sir is a law graduate from Campus Law Center, Faculty of Law, University of Delhi. He has an experience of more than 12 years in corporate legal domain and is practicing in the areas of trademark, national and international patents, copyright, design filing and registration. Currently, he is heading the legal department at Turner & Morrison's group of companies and also advises STP Limited, which is a subsidiary of Mother Paints Limited, as a legal retainer. Our next panelist is Mr. Abhinav Saxena sir, who shall also be the moderator of this webinar. Mr. Abhinav Saxena sir is an alumni of Gandhinagar National Law University. He is also the co-founder of Saxena and Kumar Law Chambers. He has an experience of almost 11 years and is also the co-founding partner of PRACOLEARN. Before I start and hand over this webinar to Mr. Abhinav Saxena sir, I would request you all to kindly keep their microphones on mute. I would also like to request the participants that in case of query, they can put up their queries in the chat box, which shall be taken in the Q&A session. Also, in case of any connectivity issue, we are streaming live on YouTube and links have been provided in the chat box as well as on our Facebook pages. For those students who have not registered and for e-certificates to those students, links have been provided on our Facebook and YouTube handles as well. I would now like to request Mr. Abhinav Saxena sir to kindly take the command of this webinar further. Over to you, sir.
Thank you, Monica. Thank you. Good evening to all of you. So, I shall be giving the introduction of this webinar. So, intellectual property rights in general refers to the set of intangible assets, including inventions, creation, and contribution to the contemporaneous field of knowledge, which is owned and legally protected by an individual or company from the outside use or implementation without approved consent. The economic growth, financial incentive, and motivation for advanced innovations embedded in the balanced legal protection of intellectual property rights entails proficient, directed, and timely updated guidance in the field of IPRs. Intellectual property has assumed a vital role with the rapid pace of technological, scientific, and medical innovation that we are witnessing today. Moreover, changes in the global economic environment have influenced the development of business models where intellectual property is a central element establishing value and potential growth. Patent law. Patent law is the branch of intellectual property law that deals with new inventions. Traditional patents protect tangible scientific inventions such as circuit boards, car engines, heating coils, or zippers. However, over time, patents have been used to protect a broader variety of inventions such as coding algorithms, business practices, or generally modified organisms. Patent is one of the ways through which the scientific inventions which have a potential for industrial application are being protected and thus promoted. In India, however, very few scientific organizations and much less industries take adequate measures to protect their inventions by getting a patent in respect of them. The importance of patents has increased tremendously over the last few decades, which is evident from the fact that every company is now creating its own strong patent portfolio. It is thus important to know the advantages involved in getting a patent and also as to how does the patent benefit an inventor. Trademark. A trademark provides protection to the owner of the mark by ensuring the exclusive rights to use it or to authorize another to use the same in return for payment. Trademarks promote initiatives in the enterprise world by rewarding the owners of trademark with recognition and financial profits. Trademark protection also hinders the efforts of unfair competitors, such as counterfeits, to use similar distinctive signs to market inferior or different products or services. The system enables people with skill and enterprise to produce and market goods and services in the fairest possible conditions, thereby facilitating international trade. Then comes a copyright. Copyright is a right given by the law to creators of literary, dramatic, musical, and artistic works and producers of cinematograph, films, and sound recordings. Creativity being the keystone of progress. No civilized society can afford to ignore the basic requirement of encouraging the same. Economic and social development of a society is dependent on creativity. The protection provided by copyright to the efforts of writers, artists, designers, dramatists, musicians, architects, and producers of sound recordings, cinematograph films, computer software creates an atmosphere conducive to creativity, which induces them to create more and motivates others to create. Then comes your industrial design. Industrial design plays an important role in the trading of consumer goods or products. Industrial design are what make a product attractive and appealing. Hence, they add to the commercial value of a product and increase its marketability. Today, industrial design has become an integral part of a consumer culture where rival articles compete for consumers' attention. It has become important, therefore, to grant to an original industrial design adequate protection. When an industrial design is protected, this helps to ensure a fair return on investment. An effective system of protection also benefits consumers and the public at large by promoting fair competition and honest trade practices. That apart, protecting industrial design helps economic development by encouraging creativity in the industrial and manufacturing sectors and contributes to the expansion of commercial activities and export of national products. Then comes the GI, geographical indication. A geographical indication is a sign used on goods that have a specific geographical origin and possess qualities, reputation, or characteristics that are essentially attributable to that place of origin. Most commonly, a geographical indication includes the name of the place of origin of the goods. Agriculture products typically have qualities that derive from their place of production and are influenced by specific local factors such as climate and soil. It is important to know the legal position relating to geographical indication of goods in India. Why do geographical indication need protection and how geographical indication are protected? Who are entitled for registration? Which of the geographical indications are protected? Who are entitled for registration? Which of the geographical indication cannot be registered? And when is our geographical indication is said to be infringed, etc. This question might be coming in your mind. Then, in modern technology, integrated circuits are essential elements for a wide range of electrical products, including articles of everyday use, such as watches, television sets, washing machines, and cars, as well as sophisticated computers, smartphones, and other digital devices. With the advancement of this information technology, a new branch in the field of intellectual property flourished, called as the layout design or the use of the semiconductor integrated circuits. India is among the first countries in the world to have passed legislation granting farmers' rights in the form of Plant Varieties Protection and Farmers' Rights Act 2001. India's law is unique in that it simultaneously aims to protect both farmers and breeders' rights. The Indian case assumed immense importance due to the country's lead in establishing a legal framework on farmers' rights, and also significant as the Indian Gene Center is recognized for its massive wealth of plant genetic resources. So, knowledge is what happens to information when human ingenuity is applied to it. Information alone does not confer competitive advantage, knowledge does. It is human ingenuity that turns information into knowledge and gives its value. And it is this knowledge that is the underlying value of the intellectual property or capital of an organization, its relationship, know-how, confidential business information, and trade secrets. Today, more than ever, intellectual property also includes confidential business information, trade secrets, know-how, and key business relationships. The various statutes that have been enacted provide an adequate mechanism of protection to intellectual property rights. However, some ideas cannot be patented, and indeed, some innovators do not want to patent their ideas, for instance, trade secret or confidential information. If a trade secret is really kept as a secret, the monopoly on an idea or product will never end. Once the information is leaked and goes into the public domain, it is lost forever. So, effective management of intellectual property enables companies to use their intellectual property rights to improve their competitiveness and strategic advantage. Acquiring intellectual property protection, no doubt, is crucial, but its effective management provides much more than just protection to an enterprise invention, trademarks, designs, copyrights, or other allied rights. So, basically, this is the intro part, and the rest will be handled by Mr. Anupam Sinha. Sir.
Hello, good evening, friends. This is Anupam Sinha. Hope all are doing well in this difficult times. This is a difficult time, and now we have to adopt a different technological mode to do our academic and all these professional things. So in this time also, now the importance of IPR increases tremendously. And so the idea of IPR is gaining day by day much improved importance in our life. And now our topic for today's discussion is intellectual property rights and its practical aspect. So what we will be dealing today is its practical aspects. What we study in college is entirely different from the practical application of IPR laws. So how we get registrations, how we do the check the infringement of products, how we get the registrations, how the registration process happens, what are the basic hurdles in the registrations. So we'll be dealing in all those aspects and some practical aspects which are emerging in the field of IPR right now. So the PPT which has been shared with you guys has the first slide says the why India needs more awareness and more professionals for the IPRs. Basically, the IPR as a way taught in our colleges is make it very cumbersome and very difficult to understand, and it has different branches. So people don't consider it to be very viable. Basically, what happens in IPR practice that there are two sets of IPR practice basically happens. One set of practice is for those people who go for the registration work, like prosecution we used to say it, that they are basically concerned with the registrations of the various IPRs. And another set of practice is that where people go for the litigation part of the IPR. So it is the scenario in India that the person who is well versed in the registrations of the IPRs is not very much familiar with the court aspects and the litigation aspects of the same IPR thing. So we need to get an aware legal professionals who should have basic ideas of both the things, that how the registration process happens and what are the basic hurdles in the registration. And another aspect, the registration person should also know how we proceed for the litigations in the IPR domain, like when the registration, how the registration happens, what is the process of registration, what sort of forms are filed with the registrations, what is the IP office, how the IP office functions. These are the things which are basically handled by the prosecution lawyer who used to file the registration for the trademark and all. But when you want to file the litigation, then in the same IPR office, you have a lawyer who is handling the litigation. He is not well versed with the filing system. So it's very difficult for a company or a professional to get ideas and coherent ideas from same time. Like what happens, there is a concept of rectification of a trademark. So when you file an IPR litigation for infringement of your trademark, somehow you got to know that the defendant has some trademark which is there and it has somehow get it registered. So you have to file a rectification. Then that lawyer who is handling your IPR in a big firm, who is handling your IPR litigation, will not file that litigation or rectification proceedings before the registry, because it's a file before the registry, trademark registry. So now he has to go to you have to go to the different person of the same field or different field to file the rectification. So it's very difficult for a person to coordinate between these two, and in that way the person who is handling the company's especially in the company, should have a sound knowledge of both the things, so that he can coordinate between both the tools. If a person knows only about the registration works, then he cannot coordinate better with the persons who are handling the litigation. And if you don't know the procedure of registration, then he will be fixed, because there are lots of small things that you have to know for the registrations. For litigation, you need a separate set of things. For you shall have an idea of CPC, but for registrations, you don't need an idea of CPC. You need to know the Trademark Act and the trademark rules. So we need a better aware people and better trained people in IPR, so that these gaps between the IPR prosecutions, litigations, and between the client and all are bridged. And we have lots of people in the top managements who have don't have a much idea of things. So generally they confuse between the patent, they confuse between the patent and design, they confuse between different branches of IPR, where we should get a registration, whether should we get a trademark registration for this, or whether we should get a copyright registration for this, whether we should get a patent for this, or whether should we get a design for this. So we need better trained IPR people, so that the IPR practice flourish in India, and we get the international concepts which are far more developed in the international arena should be adopted in India. We are not as adaptive, or we are not that advanced in the IPR jurisprudence as the European and Western countries are developed. So we need to enhance our level. Barring few high courts, our lower courts are not that much trained in the IPR domains. So we have to understand this, and so the IPR awareness is very much important. So, and the second issue is the IPR career option for the law professionals. The law professionals, the young law professionals who are going to adopt a career anywhere, whether as a litigant, whether as a company lawyer, they must have knowledge in IPR. If you want to be in a company, then you should know the IPR, because in the days every company, whether he has to get it registered his trademark, whether there is a patent or a copyright and anything, any small things, even the trade secrets, but what we call trade secrets, you need to know what in India we don't have a specific law to protect your trade secrets. So what we do, we go for NDAs, non-disclosure agreements. So you should know what are the basic contents of the NDAs, that protects our trade secret. So how we do it for it. So for a young lawyer, it is very important to have a good and sound and practical knowledge of the IPR. Now the IPR is governed by the journal system. Yes, so IP registry. We need to understand that how the IP registry works in India. The IP offices in India, you can go for the IP India website and search for it. Like patent, we have a Delhi, Kolkata, Chennai, and Bombay. So the Kolkata is the head office and Delhi are the branches. So there are jurisdiction divided. So the Delhi jurisdiction, well, certain states can file in the Delhi jurisdiction. The Kolkata is the head office. There's a Chennai, certain jurisdiction can be filed, and Mumbai, certain jurisdiction. The trademark, we have 5 registries. Delhi, Kolkata, Chennai, Bombay, and Hyderabad jurisdiction where they can file that. For copyright, we have a Delhi. For design, we have a Calcutta design office. There is. So we have to understand these things also, so that where we have to file, what we have to file, these are governed. These are very basic things we have to understand, that how a trademark is filed, whether we have to file a trademark in Delhi or a Calcutta. So that you have to see that where is the registered office of a company. Then so that you have that will decide jurisdiction. So these aspects which are there, you have to understand these practical aspects for filing of an IPR right. So the next topic is the COVID and the impact of the IPR governance. Now the COVID and IPR governance is basically what has happened, that the registry filing is going on, because everything registry filing is in online in India. You need not for only for the examination or for the opposition hearings, you have to visit the IP offices. Otherwise, you can do all your work online. You can file applications online. Everything you can do online. So you need to obtain for the trade for the patent attorneys can file the patents online. They can file for examination, and all the things they can file online. They don't need, not only for the certain proceedings before the examiner, they have to approach them. So in the COVID era, the IPR is not hindered, although the work as registry has affected because of the closure and all these things, but the office of the IPR is working professionally. But most importantly, the IPR litigation part is hindered, as the courts are not proper functioning. Even then, the IPR courts are functioning because they are the courts which are open now for the VC are taking the urgent and important matters. And as you know, 39(1) and 2, 39(1) and 2 gives then urgency to stop the infringement. So even for the litigation also, there is a window for IPR lawyers to work in these COVID different times. So in this difficult COVID times, you also can work the IPR. The IPR work has not stopped. The filing process and the requirements we will deal separately for the each and every act. And then what are the trade secrets, the burning issues in India? As I said, the trade secrets is the burning issue, and we don't have, when we don't have any particular specific legislation in India to protect the trade secrets. Although we are signatory to the TRIPS, and the Article 39 of the TRIPS says that we should have a separate legislation, but India in general doesn't have till date a separate trade secret protection legislation which gives us the specific input. We protect the trade secret under the common law practices, and we have different acts and schedules where we can protect our trademark, the trade secrets. We can deal with separately when we will be touching the specific trade secret topic. We will be dealing with that. So presently, but what is important, that India generally company for know-how the trade secrets go into a non-disclosure agreement. We first enter, whenever we enter with whenever there is a merger and amalgamation, there is acquisition, something happened, any technology transfer, the companies go for NDAs, non-disclosure agreements. Even a simple thing, the companies go for NDAs, and their NDAs, non-disclosure agreement, take a very vital role in protecting your trade secrets, trademarks, know-how, because they have very stringent provisions, and courts give very weightage to these NDAs. So we should be very concerned about the NDAs and all. So now the second issue is various types of IPRs. So the various types of IPRs, traditionally we have 4 or 5 types of IPRs that are patents, trademark, copyright, designs. And now we have added the areas. Now the areas are adding where the trades left different conventions. Being a student of law, you guys know that we have entered lots of Paris Convention, Berne Conventions, Madrid Convention. All these conventions added different layers of IPRs, and the TRIPS gives the basic protection to the IPR in the corporative global world. So the protection, every country wants their IP rights to be protected in the country they are going to enter. Now the economy is open. Everybody wants that IPR should be protected. So new domains and different aspects of IPR is emerging, and the WTO wise different treaties and pressures are pressurizing different signatories to introduce new IPRs in India, so that the IP rights of the holders should be protected. So basically we have patents, trademark, copyright, industrial designs, geographical indicators, layout designs of the integrated circuits, the plant varieties and the farmer rights, and the trade secrets. These are the some categories which deals in the IPRs. So now we go for the first topic is patent. All you know what is patent. I'm not going to deal with the theoretical aspect of what is the patent, what is the basic things of the patent, how the patent is gone. I am going to deal with the basic changes that you have to be concerned. When a law student or a law professional, he should be concerned with what is the applicability part, because the theories are readily available now. The availability of the internet and the search material, lots of theoretical knowledge is there, but you have to able to filter what is required for you, what you should know, what is important for you, because lots of books, lots of material is there, but that won't help you. You need to know that what I should know, that will help me in my company, in my job assignments, in my filing. If you are a lawyer, what you should know, how you should tell the clients what is there, what is not there. So the patent laws. So you need to very much concern about what's the rapid changes happening in the patents law. Like the patent law 2005 amendment made a sea change in the patent laws in India, where we allowed the product patents in India. The product patents and the process patents are two different things. This is a very important thing that you should understand, that prior to 2005 we only had the process patent in India, and a product was never patented for certain things. For certain things there was not a product patent available, and for that it was very problematic for the international drug companies, because anybody can make any manufacturing drug. They can just adopt a new process and then get a drug, same drug, and they can get a patent. So that is very much very much problematic for the Indian people. So we get a so by the pressure of WTO and all, we get a product patent regime, where the product and the process both are patentable. So, and the concept of evergreening was done away in the famous Novartis judgment. What Supreme Court has done, that the evergreening, tweaking, which was done by the international company to evergreen its product. As you know that the patent is for 20 years. We know that everybody knows that the patent is for 20 years. So every 20 years they come up with something new, slight change in the idea of in the composition of the drug, something new, the small thing they introduce, that they and they say that this is the new, this improve the efficacy of the drug by 30%, 40%, 50%, and then it should we should get a new patent, and thus they evergreen the products. This is called the evergreening, which was done away with by the Supreme Court in the famous Novartis judgment. The Supreme Court said nothing doing. The section 3D of the Patent Act applies, and you cannot evergreen because this way we can get the cheaper drugs. Because every time the big multinationals used to introduce something, some new salt on the drug, some new salt, and then they say no, this salt improves the efficacy, and we have to renew also, and we have to get a new patent for this, and this the evergreening was stopped. So we have to learn that what has changed. We have to see the international, how the dynamics of the law has changed. These are the sea changes in the law. So we have to be concerned with the sea changes, the new dynamics of the law. So we as a lawyers should be much more concerned with what is practically happening in the field. What is practically happening in the field? How the patent law is evolving, how the things are changing, how the companies are approaching. So as a company lawyer, if you are aware of these things, then also you can advise your company that no, we have to invest in the patents, we have to invest in the research, because now the evergreening is gone, the product patent is there, so we cannot just process the same product in a different way and get a patent for that. So this is not done. And then patent database and patent information system. So for the filing of the patent, it's very important that you should have a good access to the good patent database and the information system. Because what we have to do when a patent has to be filed, we have to do a prior art search, whether there is, because patent is given for the novelty, new invention. Very important, they think there is the patent thing that the novelty, the new invention should be there. So for that, you have to check whether this invention of mine is existing in the system. So you have to have a good patent database, patent information system, where you can search the prior art. You have government also providing a database. Different companies provide different databases. Different institutions have different databases for that. So you need to understand and you need to access those. You just randomly go there. You randomly check your things. You randomly access the things, so that you start getting the feel and the idea. You don't get in the book only that what is this, what is that. You go for these practical things, checking the databases on and all these things. So then we have the preparation of patent document. That is very much important. How the patent documents are prepared. For that, there are two different setup systems for the patent. What we do for the patent filing is there are two sets of forms are filed. Like first we have to file whether we can file a provisional specification and the complete specification. Then the best thing is that you should know that what is the concept of provisional specification and what is the provisional concepts of the complete specification, because then you can get an idea then how you can file these things, how you can go for the different idea. Like for the provisional, what happens in the provisional specification, you file a provisional specification which is very basic, which is with the very basic of the few aspects of the act and not in detail. You file the basic tenets of the patent, and then you file the provisional specification, so that you get a priority date, and then after then you have a 12-month window filing the complete specification, and then the entire process again after 12 months happens. So it's very much important to know that what is the provisional specification, how the complete specification is formed. So the provisional specification is filed with basically raw basic the raw aspects of the invention, and so that you get the priority date first. So you file it first, and then the in between which is going on, you get a 12-month window, and then you file the complete specification, and then publication, and then the publication and the examination report, and all those process happens. So So that is very much important, that we should know that what is the complete specification, what is the provisional specification, what is how much time window we get, how we have to improve, how we have to do the things, what are the and then you should know, we should be very much concerned about the pre-grant opposition, we should be very much concerned about the post-grant opposition. Pre-grant opposition is very. So we were at the provisional specification and complete specification. What is the provisional specification? What is the complete specification? How much time we get? A 12-month time. Then the early publication happens. Then early examination request is made. Then pre-grant opposition is there. So we have to understand that the moment we file the patent application, we should not go in market. Otherwise, the pre-grant opposition may came. So that these things, these small things, we have to be taken care. And then the patent infringement and the recent development in the patent system, the infringements of the patent infringement, and so there are two different types. So when there is when you file that there are patent infringements, then you go for there are civil remedies available, there are criminal remedies available. You go for ante and penal orders. So in that way, you have to protect your patent. And then there is a very much problem that even in the patent law, the defendant may even challenge the basis of your patent. So the patent litigation infringement, you should not be filing you should not go for prosecution where your patent claim. You should not. First of all, we should be very much sure that this is the new. We should do all the homework research, the priority art search, non-existence of patent, and then we have to file the patent. So that it is not that if you get a patent, then even then your patent cannot be challenged. This is the aspect of the patent law in India, that even a patent is granted. Even a patent is granted, then you file for infringement of your patent, and then the other party, the defendant, will challenge the basis existence, your patent. So the patent infringement cases are very much complicated. In this aspect, now what we have to do, the standard essential patents in the FRAND licensing. What is happening there in the Micromax and Intex cases against this Ericsson is that these very companies are challenging the very essentials of the patents claimed by Sony Ericsson. The Ericsson, they are challenging the very basis of the patent of the Ericsson, that their patents are not taken bona fide. They are not bona fide patents. There is some problem in the patents. They've been earlier published somewhere. So that's why the patent is essential patents and the FRAND licensing. This is the emerging field in the patents area in India. Now we all know that there are lots of litigation between the mobile companies of India for the patents in India. The Sony Ericsson has filed big plethora of litigation against the lots of Indian companies for the patent infringement. What happens there? What is the standard essential patents? We have to understand that if some technology is there, that it has to adopt certain standards. If some technology is there, then there we have to adopt similar standards by each of every company. Like if we have a phone of Sony Ericsson and if we have a phone of Apple, if both the basic essential features, the hardware technology and all, are not the same, compatible with each of the two devices, the two devices will not work at the simultaneously. Like the Sony Ericsson person cannot make a phone call to the person having the Apple phone. So for this, both Apple phone user and the Sony Ericsson phone user should have a standard of the technology they are using. So for that, this is called the technology standard essentials. Standard essentials organizations define the standard essentials. Standard essentials organization defines the standards of a technology, and then these technologies, they are defined, and then a patent is obtained, and then a patent, and for that, and if the technology is used, and then any company has that some technology for that, then he obtained, and then patent is added in that, then it's called standard essential patents. So that is called standard essential patents for the same technology. And then what happens in the FRAND is the terminology used for licensing in that. So what happens if Sony has some technology and the Apple want to use it, then it will give a license to the Apple. Sony will give the license to the Apple to use that technology. So that is called the FRAND. But what happens in that, like we have a GSM chip, which is the used in a 1000 rupees, say 1000 rupees mobile. So that for that company will get a 10 rupees royalty for that. But if that same chip is getting used in a 10,000 rupees, then that company will get 1000 rupees for that. That is the problem. That is the problem. That is the problem in the areas of the standard essential patents and the FRAND terms, because the FRAND terms are not fair to the licensee partners. So there are lots of litigation happening. What happens in Ericsson cases and all these cases is this, that the people are not using the fair, rational and clear-cut terms for the standard essential, for the FRAND and all. So these are the things we need to understand, and we go for the research. That there was a case in the Competition Commission also, there was a case in the Delhi High Court also. So we have to go for these cases, we have to search for these cases so that we understand the latest dynamics in the patents, what is happening in the patents. Now what is that no-parties judgment we have dealt, the standards, the effect of the no-parties judgment of the patent law. The no-parties judgment, that is evergreening of property done by the companies has gone. So it has a sea change in the dynamics, the product patent and the evergreening of the drugs. Now we can get cheap drugs in India, because that is very much important. What was happening there in India, that people are getting their drugs, their patents renewed every time, every lapse of every 20 years, and they are misusing that system. So these things we have to do. So or not only we have to understand the patent, the concepts of the patent, but we have to go for the acts also. What are the relevant sections of the act? We have to go for the rules also. Now we have to go for the other topics. So let's proceed for the trademark also. The trademark, how we do for the trademark. So what we learn in the trademark, the transported reputation, well-marked trademarks, what is distinctive, what is on and all, that all we read in the classes and all. But we should know also how the registries functions, how we get a trademark registered, the trademark registration, how is the registration process happens, what we do for first. Now when you join the litigation area, the filing area, what you have to do first, that what you need to understand, that how the trademark is filed. So you have to go to trademark rules. Now earlier they have lots of trademark forms. They were all together 40 and 50 forms. Now they have reduced it to 4 and 5. Now what trademark form like trademark form A, we have to file the trademark form A. Now what is the important part of the trademark filing? Trademark filing, the important thing is that you need to know that we have to understand that in which class the trademark forms. So now you have to go for the class deciding. So for the deciding of the class, what you need to know, the classification under which the classes are decided. So in India, though, there are basically 45 classes, but in the schedule you find the classes and there are broader classifications there. But in go for the filing in the China, then it's very difficult, because they have defined every article in that trademark filing schedule, and then you have to pick the individual product, and then you have to pinpoint that every product you have to name in the trademark filing list, everything. In India we have a broader trademark filing class, but that doesn't happen in China. In China you need to know what is the specific number. So we follow the NICE classification, and there they have a description of different things. So you need not only to go through the rules, You should also search for the niche classifications. The niche classification, how the niche classification happens, what are the different product, different classifications of product you should have that category and this classification list with you for filing. Then you need to know the user. What is the user of the trademark? These are the basic things that in which class I have to file. What is the user? What is the address of the proprietor of the trademark? This is the form A is filing. There is a concept of multi-class application is filed. So we file the multi-class application in class 99. So when you go for trademark search also in the trademark, when you visit the IP registry search and you want to find the trademark search, then you have to enter the name of the mark you want to search, and then you also need to input that that class in which you want to go. So you need to know the class also. You need to know the different things also, class and all. So there are there's the trademark. There are multi-class application can be filed. That in a single application you can file 3-4 applications. So for that, what number you have to put there? That you should know that the 99 is there. You get the multi-class applications also. So you should know that the trademark filing is very, very broad. We get a lot of things for the filing of the trademark. But different trademarks are there. That the generic trademark, descriptive, suggestive, arbitrary, invented and coined trademarks. The generic trademarks, we don't get a generic trademark generally. Descriptive trademarks, we don't get them because they are a specific bar under the Trademark Act. Suggestive trademarks, very rare. Arbitrary trademarks and inventive and coined words. So the best thing is that we should suggest that we should invented and coined words, that arbitrary words like the apple for computers. Nobody, this is an arbitrary trademark. So we got a better protection for the arbitrary trademarks. But we can get lots of, if we go by the trademark registry Trademark Act, we can get a licensing for heading, label, ticket, name, signature, word, letter, numeral, shape of the goods, color combination, packaging. So it's very important that we should know that that the trade name, which difference between the trademark is what? This is the trade represent. That is basically the thing which represent my trade from the other person's trade. So we can even get registrations of a shape of something is registered as a trademark. Like you very well know that Little Heart biscuit by Britannia. Recently, they get the shape of that Britannia biscuit registered as a trademark. So they get a protection from the Trademark Act, and the trademark protection is very wide. So we get a protection in the shape mark. So the shape mark is a very the shape mark is a new domain that people are getting to learn. That the shape that we can also get the shape. It's not only the name of a company will get the protection. The color combination also get protection in the trademark. And like biscuits packets, lots of things. The companies adopt a certain traits, like the color combinations adopted by the Colgate and the Palmolive. There are litigations with the Colgate and the Palmolive. The different companies stop them using the color combination, not only the mark. They stop infringing the color combination adopted by them, because these are also the infringement of a registered of this company. And the very important thing that we should know, that the registration of a trademark is not very much important for filing the cases or the infringement cases. There are the concept of passing off. What is the concept of passing off? The concept of passing off is acquired under the common law right. So lots of people are under the impression that no, only the registered trademarks are protected. It's not that. For the litigation of a trademark, it's very much important that we should have a register. We should have a user. The user is foremost important thing in the trademark litigation. So if we can use the prior user, there are various cases in the litigation arena where the registered trademark is stopped by the unregistered trademark owner by the basis of the user. So registration is not the sine qua non or the best thing in the trademark registration. So we have a common law right of trade infringement passing off. So there we can stop the infringer. So the color combination, the shapes, all these things is very much important. The shape and the acquired distinctions are like the Kit Kat shape, which has they say that it has acquired a distinctiveness. Did not get the registration in US. There is what I said, that there is a very stringent procedure over there. But in India, we get the things easily. So in India, acquired distinctiveness are that little hard biscuit shape, get the registration in Britannia. But in US though it doesn't happen. So the trademark registration in the digital world. So digital world, the filing is in the entire filing of the trademark now is online. So we have to be very particular, and the for the we have to be aware of the what are the procedures followed by the trademark registry in filing what essentially we need. What as being an advocate, there is no basic requirement for filing at the of the trademark. Any lawyer is a trademark attorney. This is not the case in the patents. Whereas patents, you need to have passed the patent agent examination, and for that, even only the science graduates or BE BTech can appear in that examination. So for the arts background people who are not the science graduate, the trademark attorney, the trademark dimension is very much important for them. We have a very large trademark registry thing. We have a very much large trademark registry filing. We have very large trademark litigation in India. So those person who wants to practice in IPR, trademark is very lucrative field for them, even for the arts graduate. It's not so much technical like patents. Is very much technical when you go for the claim drafting and all. So so it's very much important that we should that as a law student we should know that whether we can go if we are not a science graduate, that we should not be very much inclined towards the patents and all, because we don't have a future in the patents. But we have futures in the trademark and copyright and all these things. So we must also be focused. We should be smart enough to plan in advance that which area we should focus, which area we should go for. Like if you want to, if you are a science graduate, then you should go for the patent attorney examinations. You should prepare for that. It happens every year. Usually it happens every year in India. The trademark IP department of India, the IP registry of India conducts these examinations every year. So you should go for the patent attorney examination, and then you will be better placed in any organization and in any litigation area. So like this, so we should know that the comparative advertising and product disparagements. This is the new field emerging in the trademark litigation in India, that lots of companies are now making disparaging ads, and they are trying to disparage the other products. So we have a very stringent court rules there that no, you cannot disparage another company. You can say my product is 100 times better than any company's product, but you cannot say that his product is bad, because disparagement is not allowed. This disparagement is a concept in the trademark law. This is not allowed. So you need to understand that in a company, when a lawyer, when you got to know that a disparaging ad, even the disparaging ad where you make fun of somebody is not allowed. So you need to understand the concept of what is comparative advertisement and the disparaging advertisement. The competitive advertisements there used to be norms in India, but now the courts are taking very stringent view about the product disparagement, and they are very strict. They say no, disparagement is not allowed. You cannot disparage other products. You can say your product is far much better, but you cannot say that his product is bad. So that sort of disparagement, even the implied disparagement, is not allowed by the courts. Recently, some ad was there by the merger against the different set of companies. Then the Delhi High Court said, no, this is not happening. We are not allowing disparaging ads. So the disparagement is not allowed. Lots of cases, Safis and all, different cases, this disparagement is never allowed. So we should understand that disparagement, that in the garb of the competitive advertisement, you cannot disparage anybody's product. Now the latest dimension in the trademark area is section 135, this section 135 and section 62 of the section 135 of the Trademark Act. The section 134 of the Trademark Act is now gain importance all of a sudden by the Sanjay Dalia, that IPRs judgment. This section 134 and section 62 subclause 2, subsection 2 of the Copyright Act give the specific right to a trademark and the copyright owner to file the trademark in their jurisdiction, whereas the section 20 of the CPC says that you have to work, you have to file cases where the defendant works for gain. But now these gives you special rights, because trademark is a special right. How far a person, a trademark owner, can change a person in the areas in his domain. So this is the special right given in the trademark law. So this is the special power given in the Trademark Act. So now there is a sea change by the Supreme Court IPRs Sanjay Dalia judgment, where they said no. If you have a principal place of business and the infringement happened, like say if you are placed in Delhi and the infringement happened in Ahmedabad, and you have a subordinate office in Ahmedabad, then you have to file the cases at Ahmedabad, and then lots of things happens, because this section 34 is used by the big IPR firms and big companies to get better judgments. As you know that the trademark law is not so involved in India, the IPR laws are so much involved, so we get a better hearing, fair hearing. We should not say that, but that's the case here. That we got a much more better lawyers, better researchers, better everything in Delhi's and big centers like Delhi and Bombay. So people used to file their cases in Delhi and Bombay and all. So now that choice of jurisdiction is more or less restricted by the courts under this garb. And in Delhi High Court, it goes further in Ultra Homes, where Mr. Badadurej Ahmed, the judge, has given a specific chart that where you can file, even if your choice for the principal place of business and subordinate office is gone, and then you have to file where the subordinate place is there, and there are then you have to see that chart. There is a specific chart given, and then the Bombay High Court has some different views on that. So we have to go into the dynamics of that. What happens in the dynamics of section 134, and then we have to understand these things in the realm of latest evolving laws, so that we could understand that where we can file. This is the basic litigation. When a case is filed, the jurisdiction aspect is very basic. The jurisdiction, whether you have filed the proper jurisdiction or not, whether 711 will be filed against you. So this has made the litigation quite complicated. So we should have an idea of these changing aspects of every trademark and every law, every aspect. So these are the things which affect your litigation profile and all. So we should be very concerned about these. We should go about this. The Trademark Acts and the rules, which is the another thing latest. So we have to. So best thing is that we should go at the IP India website and download the acts and the rules. The rules are changes. Now there is a sea change in the rules. So there is a sea change in the rules also. The rules are like the fee for the filing of the trademark has increased. It has increased. Now the forms have been reduced. So we have to go for the rules also. The rules are very much important, because so we have to see the real rules. What are the rules there? What is the act is the principal act of earning, but the rules give you the basic nitty-gritties of doing things. Like what are the forms? Forms are there in the rules. So what are the fees? How the fees has increases? What has increased? What is the things? And then you have to understand what is the trademark journal? How the journal is there? How is the trademark? How do you do the trademark search? How you do the trademark search? When you do the trademark search, you get a trademark report, and then on the basis of that, you ascertain to know that this mark is available for filing. Then you file it. Then there is a window. Then that mark is examined by the examiner. Then the examination report came. Then it published in the journal. Then you should know how we access the journal. The journal are there in the published in the IPR website. You should access the journal. You should go. Then the mark is published in the journal website. Then journal is published, and then there is opposition is there. So you have to keep a watch. There is a window given. Statutory period is given for the filing the opposition. So the opposition. So you should know these basic things, that how much time we have to see, that what is the opposition period, how we have to keep on checking that the some opposition is filed or not, and then what protection we have to take. So these are the basic things in the trademark prosecution also, and in litigation also. You have to collect the data before the filing, how the trademark filing is done, how litigation, that you adopt an ante-pillar order, that you can search the premises. For that, you got a appointment of a local commissioner from the court, and then you go and you search the premises. There, what is the procedure? How the report is prepared? To whom the superdari is given? What happens to the product? What is the deceptively similar product? What is the counterfeit? So you should understand these things and then go on. So you have to know these things, and then it is very important. You have to learn these things. When you go for internship in any organization, you should focus on these things. You should not be only on the researching in there. You should go. You should ask a senior that please take us to the IP raids. Please take us to the LC happening. Please take us to the registry, how the registry procedures is going on. So you should, when you are interning with a IP law firm, you should also focus on these areas. You should not only be researching on any aspect of the new things. You should also involve yourself in the practical things, so that you got to learn the major new areas there. So this way, now we should proceed to the copyright registration. So fundamental to the copyright, which is taught to every law student, that only the work is protected, not the idea is protected. Today we have a question also, that what is the doctrine of merger of idea and work protection. So the basic things that we know, that only the expression of the idea, the expression is protected, not the idea. Idea is never protected. And if there is that the idea and the work, or the idea and the expressions are inseparable, then you will not get the copyright protection in India. So the copyright protection is, and the copyright infringement and John Doe order. John Doe order is a new thing that we should, that is an emerging concept in the US. In India, it's known as Ashok Kumar order law. Like it's obtained for the unknown infringer of the copyright. Like first time it happened when a webcast rights obtained by a company for telecast of the Cricket World Cup, and then lots of cable TV users are misusing there. Then the company said that we don't know who are the infringers. Then they got the John Doe or the Ashok Kumar order. Then this order is against the unknown defender. And there the court commissioners were given right, they can search the premises of the unknown person who are not the party to the suit, and then take photographs and prepare the reports, and then they were later on added to the suit. So these emerging things give the protection to the people in such grave scenarios. Because what happens if we keep on searching, there are lots of 200 cable operators who may be telecasting these. Until then, we find out all, we suffered that company would have suffered a big loss. So the John Doe orders or the Ashok Kumar order that we known as in India gives the special protection to the copyright holder in this aspect. Section 15 of the Copyright Act is implication in design registration. So this is very much important, that shape mark and all these things. So the section 15 of the Copyright Act clear-cut bars the registration of the copyright protection for whom the design, we can get a design registration. Like if we have a design registration for certain things, we cannot claim the copyright protection for that. And this section, the part 2 of this section 15 says that even if we don't obtain the design registration, and if that article is produced in an industrial use more than 50 times, then the copyright protection to that product is gone. So this is the basic interplay. That's we have to understand that the design protection, the copyright protection, and all. So we need to understand these basic nitty-gritties, difficulties which are there in both the acts and all. So we could delve in the basic ideas of what are the copyrights and what are the designs, what and all. Copyright, and then the industrial design. As so basically we have to understand what is the design, industrial design. What is design? We get the for the aesthetics of any for whom we get the design. The design registrations we get. The aesthetics of any aesthetic parts, the shape of the line drawing and the design. For aesthetic part, the representation in the 3D model or the 2D model definition we go, we get the design of the design, but the basic shape has to be there. Like for a table, it should be a flat surface, and we can change the basic as the orientation of the legs and the other thing. We can add certain things to the table, but the basic aesthetic, the basic concept of the design should be there. And then we get it a design registration. Then we get that there is a design registration of that. Then there are certain things for that we cannot get a design registration. For a trademark, for a property mark, or an artistic work, we don't get a design registration. The painting, sculptures, the work of architect, the craftsmanship of architect, we don't get a design registration for that. The postcards, we don't get a postcard because we don't get a stamp design registration, because if the upon cover is moving, it's only a paper. The design is not the embedded part of that stamp. So that thing we have to understand, that we don't get why we don't get a design registration for card, token, or a stamp, or all these things, because when upper cover something removed from there, then we don't get it. So design registration has to be there. What is registrable? So we have to go from the act. We have to understand. We go from the act and then learn. And what is registrable design? What is non-registrable design? Then how the design registration is filed. So for what classification is adopted there? The local classification is adopted. What sort of things are there? How the goods are classified in the local classification? In what class we have to file the design registration? For design registration, we have to, if we file the line drawing, the line drawing is there. If the product is there, then we have to get the dimensions, the 7 dimensions photograph of the product, that we have to file there. So these basic things, how the photographs are done. If a product is done, then we get the 7 aspects, 7 angles photograph, 7 angles photograph of that design, and then that is required, and the novelty is there. These are very basic things for design that we have to understand, that what is design there in the design registration and all. How we get because if you don't get the proper 7 dimensional photographs for that product, then that will be rejected. Then you got a good cost in for the design registration, for the photographing it, and then that is rejected. Then you again go for the photography of that product. So you should have an idea. You should know the concepts, how you get the product photographed, or it's better whether we get a product photograph or we get the line drawings of that design to get it registered. So and then how the design is registration, how the design registrations, how monopoly is there, and we should know how to access the design journals. The design journals by the is published by the patent office. It's published along with the patent journal. There are journals. This is not journal. These are journals where the accepted marks are published, like a trademark journal by the IP register is a journal where the mark, once the mark is accepted by the examiner, that is accepted and then accepted for publication for the general public. Then there is the opposition time. Then there is the opposition. We need to know how the journal is accessed, how the design journal is accessed, what are the design registrations. So what are the for that we have to understand the rules. So it's very much important that we should not only go for the act, we should also go for the rules and all. Then important thing is geographical indicators. Geographical indicators is, as you know, lots of things in the geographical indicators is the new area. Lots of thing happening. Who is the authorized user? Section 17. Who get it set? Those person who get it registered in a geographical in the section 17 is the authorized user. Who is the producer? So for producer, you need to be of that area. It's what is geographical indicator? It's geographical indicator is indicating of geography, the dazzling tea and the all these things, tea and lots of things. So lots of states, lots of awareness happened in these time for the geographical indicator. People get very much aware that we should file the basmati rice and all. These are the big cases. Now when you go for the GI side, you see lots of products, lots of similar things. Even the mirchi, different mirchis from the different regions are now getting the GI tags. Even the kadaknat chicken, a chicken specialized chicken in the black color, is even that chicken is getting the GI tag for itself. So we should know how registration is for, and that is very much important that we should know the process, how the registration is done, because in this is the study. This is a trade. This Rasgulla case is the fit case for all these. What happens that West Bengal file it and the file is properly. The objection. Initially, the Odisha never took any step to oppose it. They very late came on and filed the objection against that, giving the Rasgulla tag to the West Bengal. But what is the actual case there? The actual GI case is the Bengal get for the registration for the Bengal Rasgulla and the Odisha get for the Odisha Rasgulla. It is not that the entire Rasgulla is get GI tag for the West Bengal and the Odisha is excluded. So there is a confusion. People say no, first Odisha lost, then West Bengal gain. It is not that the case. The West Bengal get the GI tag only for the Bengal Rasgulla, and the Odisha get its tag for the Odisha Rasgulla. They both, so the judgment is very clear that there is a different the taste, there is a different the texture, there is a different the color. Whereas the Bengal Rasgulla is white, the Odisha Rasgulla is slightly brown in color. So, and that the way the Odisha lost his case on the very technical ground. He does not file his objection properly and the way required by the act. So it's very important that we know these things and we should aware that how we can get the mark done and all. So basic thing is that we know we should go and learn these small things and the latest developments, and we should know the latest development is proper context. Like the people in general say no, that the Odisha get the Odisha is excluded from the Rasgulla case and the Bengal get the GI tag. It's not that the Odisha also get the GI tag for the Odisha Rasgulla and the Bengal get is tag for the Bengal Rasgulla. The proper literature needs to be there. When you file that application, lots of things are there. You need to get the text, literatures, claims from the back time. So we need to prepare our case, rock solid, so that we get a fair hearing before the registry. So we have to do our research work properly. For that, we have to understand that where a party lost his case, where a party gained his case. So it's a very fluid and dynamic case. We must learn all these things. We should go and search proper registry websites so that we can get the details, proper details, the verifiable details, and we learn the proper facts. Now, the semiconductor integrated design in India, we have a specific semiconductor IC circuits, because the copyright very late we have started giving the protection of the copyright design of the computer programs, the copyright protections. but it's very late. It came in 94 around. We start giving them. So we have a separate law. So we have a separate law for integrated circuit. So how we file integrated circuit? Where is the integrated circuit office? What is the site? We should know. We should learn on these things. This is very technical. That any arts people should not go for these things. This is new and emerging dynamics. This is in the Delhi. The semiconductor integrated circuit design layout registry is there. We have a separate site. It's Scladder, the separate site. So we should go on that site and learn by the use of the registered layout designed by the registered. So the registered user. So we give the licensing there. The person, he has to get it registered. It's not the person who obtained the license. He has to get it registered, and then he can use that IC design circuit. So these things we have to learn. We have to learn how these are filed. These are technical things. So we have to vary layout design. After that, there is this IPR and the other law. So that we have a corporate sector and the IPR. Before that, we have a corporate sector and the IPR. The corporate sector and the IPR. Now, this is very important. The corporate sector and the IPR. When a person wants to join the corporate world also, he should know the IPR very much, because in the licensing and all, in the merger amalgamation, you should know the IPR, because in merger amalgamation, IPR plays a very much important part. The entire merger amalgamation, the entire DD, due diligence happens. Basically, the main thrust is there on the IPR. What are the IP rights? How the IP audit is conducted? You should understand. You should when you do the DD, you should know that how we can cross-check, cross-verify whether this is trademark is registered or not. What are the prior trademarks they have? If any mark is applied by the company and had it been abandoned, how many oppositions are there? So for that, for acquisition, when you're going to acquire a company, you should know that this trademark of this company. What is the litigation going on against this trademark? What is the status of this patent? If you get something from the company, when you do the due diligence, then you should cross-verify it. So for that, there also you need to have an idea of IPR, the trademark registry. You should know how to access the IP, the patent office, patent domains, the patent information systems of India. How you have to access the IP registry domains. How you access the codes, registries, so that you can verify the details provided by the company whom the acquisition is going on, the merger is going on. So, like for the licensing also, when the licensing agreement has to be there, different thing has to be there. So for the corporate people also, the IPR is very much important. Now the area of advanced questions are there. So now lots of advanced questions I have already answered. Now we can go one by one. The first question it says that I have seen lots of opening IP lawyers, but most of them requires the technical knowledge. So preferably generally goes to the BTech students. So what do we, the LLB students with a technical background, needs to excel in the IPR field? So that's the very important thing. So I said that even a BSc can go for the patents. It's for the technical student. What is there? It's the patents only. But the trademark there, copyright there, the design registry is there. Lots of things are there. So it's not that for only the science background students are there for the IPR world. So it's for the BTech. We understand that for the patents, you need to have a technical degree if you have, because there is basic requirement of the science graduate, and then the company needs that he should be an engineer, because he should understand the basic process of the technical aspects of a patent, and then he can draft the claim and all. So I understood, but the patent is for the science, but other people who are there they have got for trademark and other these things. What is the career option for the law student, IPR, and the professor? I have dealt extensively for this, because there are lots of career options for law student, because the IPR is the emerging field. Lots of people are there. We need good trained people in IPR. So third question is, if you want to register an intellectual property right of a scientific project and idea, how can you do that? So you have to decide what sort of IPR is it. So if it's a patent, then you have to file a patent. If you design it, a trademark, then what you have to do? Overlapping between design and copyright in its aspect. I dealt the design and the copyright aspect. what is the aesthetic functionality of the copyright? This question is amusing. Whosoever asked it, this is the foreign concept and the evolving concept, aesthetic functionality, aesthetic functionality of the trademark, and the design is there. The copyright aesthetic functionality is very, very niche concept. That the what happens in America, this is the American concept, where there you don't give the trademark registration when there is aesthetically a very functionality of a trademark aesthetically defined in the trademark, because that some aesthetic thing, that thing which is very aesthetic in a trademark precludes other people from getting that same thing in the registered trademark. So this is denied. Doctrine related to copyright. Then the next question: what are the doctrine related to copyright application in India, like doctrine of merger? That I said, the doctrine of merger for the idea and the expression dichotomy. When the merger, when there is inseparable idea and work, that is the idea and the expression dichotomy is there, and they are inseparable. The doctrine in the merger and the copyright registration is denied. Do you think that IPR laws in India feel like medicine and sports is actually hampering the true essence of these occupations and making them more money minting industries? I shouldn't say that, because when a company puts lots of effort in getting its patent, then he should get its fruit also, because getting patents is not so easy. You have to put a lots of money in the research work, and then getting the actual patent is a very cumbersome process. It's very slow, because and a draft, it's a very costly affair. So when a company invests so much in that, you should get some feel. Otherwise, then nobody will start investing in the development. And this, like, we are searching desperately for the vaccine for the COVID. No company, if we don't give the patent protection to the vaccine inventor, then nobody will try to invest so much in this development of this vaccine. So this is lots of effort, hard work, manpower, and money goes. So they should get the fruit of it. And then the next question is how copyright should be more strict and stop the infringement. The laws are there, but the effective way should be there. We should need a smart attorneys and smart people to effect, because the laws is there. We have to implement the laws better. How long the patent and copyright laws? The patents is for 20 years, and the copyright is for the life of the inventor, the creator, and then 60 years, and for the publisher is 25 years. This is the basic things you can get it from the act, but for the patent it's 20, and for the copyright for the life, till the life and after 60 years. And when there is unpublished thing which is unrelated, or somebody dies, then it's 60 years. So this is there. What is artificial? And then the question is how artificial intelligence can overtake the credentials of the IPR legal implications. The artificial intelligence and the IPR goes hand in hand, because the artificial intelligence is the technical thing, and all these things has to be applied in the law by the IPR only. So both are interlinked and very much interconnected, because if the artificial intelligence is invented and we don't give IPR protection of that artificial intelligence, then anybody can use it and then it's gone. Then if sometime observed, when the 2% different research on the topic, most of their work are same, but they were not copied from each other. So it can one said that IPR infringe. No, that's very much important thing, that a prior filing user, that it's a patent. Whosoever gets the prior filing date it will get the patent. That's there. So he has to prove it. He has to prove by literature and all that whosoever first file is so notings are important. The things are important. That's why I said that we have to understand that provisional specification is important for getting the priority dates. We should not go for this complete specification, that when we do all the inventions all together, then we directly file the complete specification. No, we should go for the provisional specification. So we get the 1 month, 1 year window. So we are and we get the priority date from the date of the filing of the provisional specification. So and then the can intellectual property right pose the problem for the digital sharing and the digital access of newspaper. Yes, this happens this few days ago when some people are sharing the newspaper on their WhatsApp group, and then the editors associations stop them. But there is section 52 of the Copyrights Act which says that for the personal use, fair use, you can do it for the fair use of the copyright. Section 52 gives you protection there, but you should not make money of it. You should not you should make it for the then the people start using disclaimer that we are not giving it for money, we are sharing those people who cannot access the digital platform. So these things should be there. The drug if the drug is patented for medicinal use and it's misused by the people, what is the liability of patent holder? I basically didn't understand it. If the misuse by the people, then the liability then the patent holder will file a case against the misuser. And there is the do artists like painters and the sculptors have the intellectual property rights in the work after they display in the exhibition. Yes, the moment the painting is done, it's the sculpture of the painter has the copyright there, and it's subsists that unless and until it's had license. And even there is a moral right of the creator that even if his painting or is somehow misused or somehow distorted, then the moral right, he can file for this moral right. The moral rights is there with the creator. And what is the Orwell Legislation of Competition Act and the Intellectual Property Act? So this is important that the Competition Act supports the Intellectual Property Rights Act, and the Section 3, subsection 5 of the Competition Act prohibits you imposing the unfair licensing terms on the licensor. So the competition, you cannot use intellectual property rights, your intellectual property rights to use it to increase the unfair competition in the market. So Section 3, subsection 5 prohibits you from putting the unfair restriction on the licensor and all. And then section, what is the what will happen to different persons when the same things are for the same times and apply, but at the same time, how can you apply the patent same time? One will get the first licensing number. Whosoever get the first licensing number will get that. The reverse payment settlement in the pharmaceutical industry, this is not happening in India. It's a foreign concept where an infringer get the money. This reverse payment settlement concept is there we know that the trademark, the patent litigation is very complicated. It's a long drawn process. It's the patent attorneys charge so much money. So the company thought that we should settle the infringer and stop him infringing the products. And for that he pays the patent holder pays the infringer money. This is called reverse payment settlement. It is settled by paying the reverse payment, and we made a settlement, and then with this settlement agreement entered by the court, and the infringers give a word to the court that it will not stop on the use of the money. This way, I hope all the advanced questions are finished. Now, this is very much important. To conclude, being to conclude that we must have a trained IPR people basically trained who has the actual idea how the IPR litigation happening, how the IPR filing, what are the examinations we have to clear, what are the basic tenets of the IPR. We should have a practical training of the IPR. In colleges, we should not be trained only giving the books, theoretical lectures. In colleges, we should be able to access, we should be trained how should we access the IP department websites, how should we access the examination report. You can access anybody's examination report. You can access how we do trademark searches, how we do patent searches, how we see that if there is an opposition file against any trademark. So these things should be taught in the college level also, and at the internship it should be done, so that we go get a trained IPR people and the basic concepts. I don't say that the college, the training in the college is not important. It's very much important because the basic concepts, the idea of distinctively similar masks, descriptive marks, distinctively similar marks, the disparaging marks. There you learn there. That you learn there. That is the trans-border reputation that you learn in the concepts. But how they have to apply it, that training also needs to be given. We only train our people with the practical things, the bookish things. We don't train our people with the practical things so that they don't get acquainted with the what's happening in the market, and then there we face the problem. And then the trademark and IPR and everything become very cumbersome and not good. So people are not, it's very much interesting thing. It's very much interesting. It's very much user friendly. Now the students are very much friendly with the internet and all. It's everything, the plethora of information there in the internet. You can access the IP registry. You don't need any registration. You don't need any password. You can access anybody's trademark. You can access anybody's registries. You can access any patent. That is everywhere. Even GI, everything is there. But first you should know how to access them. When you access them, you learn all these things. So it's very important that you should learn all these things, and then these trainings should be given to our students so that they go into the market well trained, and then they can excel. I hope it sums up with the whole idea of this seminar.
Sir, if Anupam sir is comfortable, shall I start with the Q&A session?
Yeah, hello.
Yes, sir.
Yeah.
So the first question is by Mudabir. He asked you to explain the non-disclosure of agreements in detail.
Non-disclosure of?
Agreements in detail, NDA.
Well, NDA, non-disclosure agreements, are those agreements where, like my dear friend, when the basic things that when you share a technology, when you share some information with somebody, like you give, like a basic thing, like I decided that I sell my building with somebody. So you share all the details of the building, everything, every aspect, how much area is there, what is the history, what is the litigation, what is everything you share with that agent, and then you sign an NDA with that. This non-disclosure agreement is binding on that agent that he will not disclose all the information which is given to him. So this way, all these know-how, these technical, your details are protected by this very instrument called NDA. There you protect everything. You design everything. And then you define everything that these things will be the. You give a detailed list of what will be the disclosures, what will be the information, excuse me, what will be the defining terms, and what will be the what will be the duty of casted upon the person who is getting the information, and what will be the prosecution aspect if you infringe something, if you disclose something to somebody, what will be the cost, and what will be the action will be taken against you, what will the jurisdiction, everything is defined, so that there is a legal binding between the parties. That's these information I have received, and I am under the law to protect this information. So this is called the NDA.
So the next question is by Shauna. He asked that how do you reckon the SCP brand in India? Though SCP is to be mandatorily granted on brand terms, still no measures have yet been undertaken with respect to royalty stacking. Do you recommend brand terms to be legislatively determined, unlike the present scenario of it being determined judicially? What is your view on this, sir?
Yeah, I think so. Now this is the basic problem. Now I said you a simple GSM chip for 100 rupees mobile, for 1,000 rupees mobile phone, you pay 10 rupees only. For a 15,000 rupees mobile phone, you pay 10 times to that for the same thing. This is obnoxious, and the person, this is called the hold up. This is called the hold up, and this is very much done. Even in the front terms, the person who has the patent, they are misusing. And that's why the cases are filed by the Micromax and the Index against the Ericsson. And this is the major problem happening in the mobile world in India. A big litigation is going on in Delhi High Court and Supreme Court. A big litigation. Even a big research is going on, and this is a very emerging field, and I 100% support that there should be a legislation which stop that a person should not, a royalty stacking is that because the royalty is not for the product, the royalty is not for the technology. What you get the royalty, the company get the royalty for the product. That if a product is sold for the 1,000 rupees, then the royalty is different, and the product is sold for the 10,000 rupees, then the royalty is different. For the same thing, how can this be happen? We should have a fair frank terms, and SEPs, we should have a proper legislation for SAPs in India so that this misuse is stopped.
So the next question is by Muskan. She's asking about how licensing is patent to a third party. How can one license a patent to a third party?
Licensing agreements are done. There is a licensing agreement. You done a you do a licensing agreement, and then you allow it. Then the licensing is done by the licensing agreement.
Okay, sir. So this sums up our Q&A session, and I would like also to inform all the participants that if they have any queries related to this webinar, they can send us the questions on our registered mail ID, that is pracolearn@gmail.com, and we will revert back to you as soon as possible. Now I would request Mr. Abhinav Saxena, sir, to kindly give a vote of thanks to Anupam, sir.
Thank you, Monica. Thanks.
Yes.
So, first of all, I would like to give a big thanks to Mr. Anupam Sinha, legal head, Morrison Turner Group, and to the attendees also to give such a patience you have given for this practical aspect of IPR. Because without practical knowledge, nothing is complete in our field of law. So, and I would like to give a big thanks to our back-end team also, the IT team of my PRACOLEARN and of my law firm also, Saxena and Kumar Law Chamber. My team has worked very hard for this webinar and back-end work of arranging, organizing all these things. So a big thanks to all of you. So by this, I would be closing this webinar. Thanks.